to provide technical support. So Marianne, if you'd like to open it up.
Sure. Thank you everyone for being here today and for kicking off this Special Immigrant Juvenile State Court Clinic. We are so grateful to NIJC for coming in and doing this training with us. Our teams are so excited to get started with this. Obviously, ROPES and NIJC have had a long partnership, but this is the first time we're kicking off this kind of discrete sort of like limited scope rep clinic in this area, and we're just thrilled to have the opportunity. And so I'll leave it to you to add all the content. Thank you.
Thank you so much.
If I could jump into, hi, my name is Ellen Miller. I'm Pro Bono Manager at the National Immigrant Justice Center. she, her pronouns. I want to say thanks to Rebecca for being here from CBLS too. We couldn't do this work without you. But I also, for the ROPES people, and especially Mary, I want to say thank you, because we are so excited that ROPES committed to a pro bono immigration position, and that you are in it, and that you could join us from Boston. I think this is real leadership. This just kind of fulfills the culture also of pro bono, and then the dedication to immigration, and making sure that immigrants have access to counsel, and that it is competent and compassionate. So congrats to ROPES and Gray. You guys are a great firm. We're happy to be here. And thank you also for hosting our team that also gets to continue to learn with us during this training. So that's all. You guys are in excellent hands. So yeah.
Thank you so much. Well, good morning, everybody, and thank you for joining us. My name is Berenice Sanchez Ruiz, and I am the SAJS Pro Bono Coordinator. And today we have Dominique Mejia, who is our Justice Works Fellow, and Rebecca from CBLS, which is our family expert. And let me just introduce our program a little bit. So that there are nice pictures up there and contact information for leaders. If for any reason you didn't scan in or sign in, now is a good time to pull out your phone and scan the QR code so we can have attendance and provide you with CLE credit later on with 2 keywords that we'll be giving out during the presentation. And they'll be around the table and during lunch as well.
It is necessary for CLE. Yeah, there's 2 parts. So.
2 parts, yeah. All right. And just a little quick overview about what we are. NIJC is, we work with the National Immigrants, the Heartland Alliance, and we do have offices in Chicago, Indiana, and in Washington, DC. And we really work with pro bonos to provide these services to, for example, SAJS cases, asylum cases, and litigation cases. So we really rely on your partnership for this. And we do have a network of around 2,000 partners. And we're adding more, so we're growing, which is great. So yeah, next slide. This is a little bit of how we work in our program. When the client comes in, we do an in-depth interview, and we do find a relief for them. We accept their case, and then we place them with a pro bono attorney, which you all guys get legal support on along the way. So legal briefs, trainings, webinars, whatever is needed, we'll be right there with you. And then let's see what else. There's a lot of support. We'll be there for you. And then the client will just be there telling their story and just making sure that they're working with you. Next slide. A little bit about our partnership is that NIJC, again, will provide you with technical support, and we'll review your drafts before you file anything. As a pro bono attorney, you are responsible for the predicate order case, and you are responsible for providing the correct interpretation, and then like having representation in federal agencies. For clients, they are responsible for telling their story and communicating with you. So if anything changes in their life, you should be able to like help them along and then tell us if anything major comes up.
I think one point just to clarify here too is that while our pro bono attorneys are in federal systems, your role specifically with SIJS will be in state court, right? Because state court is that first piece that will then be able to launch them into the federal process. So slight clarification, but yeah, just so we're not confused today.
Yeah, awesome. And then I should pass it along to my colleague Dominique, who will be giving you an overview of SAJS.
Thank you. Okay, I just want to make sure that those online can still hear us. If at any point you guys have any tech issues, the screen changes, or you can't see the PowerPoint presentation, please let us know. Yes, so my name is Dominique Mejia. I'm an Equal Justice Works currently with NIJC, staff attorney, essentially working on this team. I've been on this team for 7 years now, so I love this type of work, and I'm happy to share this information and happy to have lots of volunteers taking on these cases as well. So thank you for joining us today. So I'm going to give you guys an overview about what SIJS is, the Special Immigrant Juvenile Status. It's a very special type of designation meant for vulnerable children who've been abandoned, abused, or neglected. And so the families and the children that you'll be helping today are some kids that are very in need of support. And so we're really grateful for everything that you guys are doing today. Okay, thank you. Okay, so first, what is it? It's a form of immigration relief available to immigrant children who've suffered abuse, neglect, or abandonment by a parent, or something similar under state law. So different states have different definitions of what abandonment, abuse, or neglect is. So we'll go over that today, what Illinois' standard is, but generally that is the standard for getting special immigrant juvenile status. It's available to immigrant children who are currently in the US. And its benefits are protection from deportation, and it's a pathway to residency and eventually citizenship. Unfortunately, it's a very long path to residency and citizenship, but the biggest hurdle usually is getting that state court order, which is what you guys are helping us do today. So getting that in and filed is a big step. To note is that a child granted SIJS or Special Immigrant Juvenile Status may never petition for either parent. So this is a conversation that we usually have with our clients beforehand. This may come up maybe when you're meeting with your client, but they should have already talked about this. But essentially, Congress enacted this and didn't want one parent to force another child to lie about hurt or harm by another parent. And so even if one parent is still in the picture and they've been nothing but wonderful, unfortunately, the child can never petition for them. So that is something that we have a conversation with the client and something that they have to weigh. But unfortunately, a lot of the time, this is the only form of relief that their child is eligible for, and the families decide that this is the best thing for them to provide that particular protection. Okay. So we're all lawyers here or legal practitioners. And so here is the statutory authority. If you guys ever want to go back and read through hundreds of pages of statutes, but it is something that you may have to come across when you cite to certain things. As Berenice mentioned, we do provide a lot of samples and templates. And so a lot of the definitions will be in there already. A lot of the standards will already be in there, but it doesn't hurt to occasionally cross-check, especially with some cases. I don't think any of you guys have any particularly difficult cases, but there are some, weirder cases that we may have to go in and kind of define very specifically. But that's for you guys. Okay, and the statutory requirements. So this is at federal level. So immigration law is federal. And so this is the standard. So they must be under 21 years of age. They must be unmarried, physically present in the United States. And then the key point for today's training is a juvenile court has declared the child dependent on the court or placed them under the custody of a state agency, department, individual, or entity, and determined that the child's reunification with one or both parents is not viable due to abuse, abandonment, neglect, or a similar basis under state law. And then lastly, that it's not in their best interest to return to their home country. Okay. So the juvenile court piece is the predicate order piece that we need. So this is a type of form of immigration relief that's very unique in that it requires a state court aspect to do a federal benefit, to be able to apply for a federal benefit. And so in an immigration law, at least that's very unique. And so you guys are taking care of that one point. So a juvenile court is defined as any jurisdiction under state law to make judicial determinations about the custody and care of juveniles. So here in Illinois, that includes the domestic relations and parentage court, guardianship, adoption, juvenile delinquency, and child welfare courts. All of you should be only in domestic relations or parentage or guardianship. None of you should be in adoption or juvenile delinquency or child welfare, but we do have these up here just so you guys are aware that there are other, especially for kids who are also in the system, potentially this is also available to them. Typically, a juvenile court order must be entered before the child turns 18. But luckily in 2021, thanks to the advocacy of Hillary Richardson, who just walked in earlier today, we had a change in the Illinois law. So usually, back when I started in 2017, we would have to screen children, and if they were 17 and a half, we'd have to turn them away, because we said that you guys, although the federal law says that you can apply until you're 21, because the state courts won't hear your petition, it will stop you at 18, we have to turn you away because there's nothing we can do here in Illinois, okay? So in 2021, we expanded the eligibility for these children. We created a new post-18 guardianship that allows children up to 20 and a half, essentially, apply for SIJS still. So this is something that a lot of our cases are actually going to benefit from today, which is amazing. Okay. And just because I know that some of us are more visual learners, you guys are helping us here at the first step, which is getting that juvenile court order. Once we have that court order, we then can fill out the SIJS petition, and along with the petition, along with the court order, file for a request for special immigrant juvenile status. And then if they are approved, later on, they would then be able to adjust status to that of a resident, which is a green card. Yes, sir.
Can I interrupt?
Yeah.
Can you tell us a little bit about the timeline of these three
Yes.
things currently?
So, thank you, Rebecca. Our next slide. Again, visual learners, but also for timeline purposes. So the first step is getting that SIJS predicate order, which is the state court order. All of our cases that were assigned today are pretty simple cases. There shouldn't be any complications. I think the most complicated for our Ropes and Gray associates is that there's two siblings that have different dads, and I think you just have to file separate, or I think one of them is over 18 and one is under 18.
Mm-hmm.
But other than that, this process can be done in 3 months. But from the time today till the order is granted, 3 months or a little bit less, along with the fellows, I think, or the kids attorneys that are also here. I think a lot of your cases could also be done in 3 months, right? Of course, time constraints, other deadlines, getting people in to kind of sign documents is sometimes kind of delay it a little bit. But that part of that piece can happen in like 3 months, okay? And that's because there's a lot of cases have 30-day publication notices. If you don't have publication issues, you don't have to wait for 30 days, especially if a lot of you guys have death by abandonment by a parent. And so that could even be quicker, okay? But once we have a predicate order, that state court order, we then file the SIJS petition along with it. Currently, we're seeing an approval rate of like 3 months, which is amazing. So within 3 months, they're approved, 3 months since we applied for it. But generally we say about 6 months because delays can happen on the government side. But once they are approved for SIJS, that comes with deferred action and being eligible for a work permit. So for a lot of our clients, sorry, I'll come back to that. So then, for a lot of our clients, actually, the thing that they see as more something that they tangible in their lives that is changed is actually being eligible for a work permit. Okay, so a lot of immigration is very complicated. Immigration law is very complicated. I specialize very much in SIJS, and if you ask me about something else in immigration law, I have no idea, right? So also explaining this to clients is kind of like, you're telling me, I have to do this first, and then I have to do this, and then I have to wait 5 years for something else. Like it becomes very hard for them to kind of grasp that. But telling them that in potentially 6 months, they can get a work permit, that is something that is very impactful for them, right? So a lot of our kids may be still in school, but having a form of identification, right? Knowing that they have some form of status, right? Something to be able to fill out on school documents or taxes, or even just knowing that they have deferred action, which means that they have protection against deportation, lightens a lot of our families and our clients' stress load. So just to kind of keep in mind that sometimes maybe you're as we explain kind of the timeline of things, they may stick on the work permit, and just know that you guys are helping them getting there to that focal point. Okay. Yes, Tony.
Post I-360 approval, what wait time are we seeing to actually get the EAD?
Oh, so then after they are approved for SIJS, then you have to apply separately for a work permit, but that's still about 3 months. So we've had some be approved within like 2 months. But we're saying about three just to be sure, especially because things kind of pick up in the spring. But yeah, so if say you guys are really speedy on time, pay between like 7 to 8 months from today, they could have a work permit, which is really big. Okay. So then unfortunately, even though they've been granted SIGS, if their client is granted SIGS, and they have been designated as a special immigrant juvenile status, they unfortunately there's a long wait before they can file to become a resident. The reason being is that this is a visa. And so the government has limits on how many visas are available per category. And there are a lot of kids that are applying for this type of visa, and this visa also falls under a different, a wider range of applications that are also considered to be part of this visa category. And so unfortunately, right now, the wait for a client to switch from a kid with special immigrant juvenile status to residency is about 4 to 5 years right now. Okay, so that's why having the work permit is a really big deal as well, right? Because these permits are actually, they last for 4 years, which is great. Okay, so that's the government saying essentially the delays on our end, and we don't want you to be waiting around for us to get there. Okay. In those 4 to 5 years, the client has to remain, in contact with their immigration attorney and make sure that they are not getting into trouble. But that's also on the NIJC side. So just for our robes and gray folks, you're helping us to step 2 essentially. And then, but just to keep in mind, if your client comes to you with any questions and, what is the grand goal or like, what's the goal of our meeting today? I think that's great.
And if I could just interject there on timelines, because we hear 4 years for EADs, which is really great. We are having an election coming up that might change our administration, that might have different policies, or maybe if this administration continues, they also might change course. And so this is a politicized, we're not, working or living under a rock. This is a politicized topic. And so it is important to understand what our government is or is not doing for our new neighbors and for the people that could benefit from this, for the stability of the people in our classrooms and in our workplaces. And so I will also say we are a 501c3, but we hope you vote in March primaries and in November. So thank you for trying to make sure that our system stays, the way that you want to see it for yourself and your neighbors. I will also just quickly ask, how many here on the rope side have done immigration law before? Yeah, great. Okay, I'm not going to ask if anybody's an immigrant or has immigrant family, but if anybody's been impacted by the immigration system, we know that there's a lot of weight going into these processes too, right? There's a lot of emotions and kind of family benefits. So thank you again for being here and continue to learn. Yeah.
On that note about the elections, I think we have noted deadlines, especially if the kid's going to age out. We noted that really clearly. But I think we would emphasize that we would want a lot of these cases to be done by November. Again, because policies can change, statutes can change. There's a lot of bureaucratic things that take time, but for the protection of our kids, I think that could be a priority if we haven't stated a deadline that's earlier. Okay. So this is just kind of a brief history of SIGS in Illinois. The Immigration Act of 1990 created SIGS for children declared dependent by juvenile court, but this is very narrow. So it required that children be eligible for long-term foster care. So essentially the children had completely been removed from their parents' home and parental rights had essentially been terminated for a child to be eligible. And as you guys will see, and we'll go to client stories, it's the very specific subset of children that are eligible for, and there's a lot more children that could be eligible for. So in 2003, the Illinois law incorporated SIGS into its Juvenile Court Act only, though, included dependency and long-term foster care requirements. In the TVPRA of 2008, which is a federal immigration law, multiple amendments created what is now modern SIGS. And it removed long-term foster care requirements and allows children to petition for SIGS based on harm by only one parent. Again, kind of going back to that abuse can be by one or both. In 2019, we updated Illinois language to remove long-term foster care and dependency requirements and incorporated SIGS into all of our relevant laws. So that includes the Illinois Marriage and Dissolution Act, Juvenile Court Act, Probate, Parentage, Adoption Acts to expand the courts that could enter such an order. And then lastly, in 2021, we expanded it to 21, again, thanks to the advocacy of CVLS and Hillary Richardson over here. Okay. We already talked about this, the expansion in 2021 this is the 2019 expansion, brought it in line to federal law, amended to 6 Illinois laws. A big one for you guys, especially for those that are not practicing in Cook County, if your cases are not Cook County, the Public Act requires judges to enter SIJS findings if the facts support this. In the past, we've had some pushback by some judges, either because of like political reasons or just not believing that they had jurisdiction or the power to enter such findings about pertaining to immigration law. They would not enter the specific findings that we need. So this Public Act is something that reinforces that judges have to enter these findings if the evidence and the facts support it. It also clarified that abandonment by death is also valid under state law. So again, we do have templates. We have memos of laws for you to file with the court if you need to kind of make these arguments or make these to educate our judges, but just know that the law is behind us. Okay. This is the Public Act enacted in 2021 that expanded SIJS protection to 18 to 21-year-olds. And it does provide more guidance for judges as well. Right. So the next is a kind of a where you can find our definitions for abuse, abandonment, and neglect. They are categorized by the different types of acts, depending on if it's custody or if it's a guardianship. Mainly, we'll be working out of the Illinois Marriage and Dissolution of Marriage Act and Illinois Probate Act. Okay, just to kind of highlight for those. But we did include the Juvenile Court Act, Adoption Act, Illinois Domestic Violence Act, in case that ever comes up in a different case. Okay. Okay, so kind of going over what abuse abandonment is. So abuse under the Illinois Domestic Violence Act includes physical abuse, harassment, intimidation of a dependent, interference with personal liberty, or willful deprivation, but does not include reasonable direction of a minor child. So essentially, if you're just trying to parent your child, and punish reasonably, that does not abuse, but there are a lot of instances of physical abuse, harassment, intimidation. Of note is that the Illinois law does include that if a child witnesses physical abuse of one parent to another, that constitutes abuse of the child as well. Okay? We've essentially established that a child that has a major impact on them growing up, and so that is also abuse to them. Okay? Even if that parent did not physically abuse them. Okay? Abandonment includes, but is not limited to, the failure of a parent to maintain a reasonable degree of interest, concern, or responsibility for the welfare of the minor. But it also includes if a parent has died or cannot be reasonably located. There are a number of cases here that were assigned today that are abandonment by death. And so this is a big change and is very unique to Illinois, which is great. If a parent cannot be reasonably located, it's a little bit higher of a standard to kind of establish, kind of to show history of trying to contact or locate a parent for it to be considered abandonment. But death by abandonment is a big one today. And then lastly, neglect. Yes.
Could you talk about abandonment and imprisonment, if that is related at all?
We do have one of those cases that we currently have, but in that case, the father signed off on somebody else getting guardianship, I think, of the child, but that parent had a history of being neglectful towards the parent and not being, towards the child and not being in that relationship. Just because a parent is incarcerated, though, does not mean that they're a bad parent or that they do not deserve to have their parental rights. So I think it's kind of weighing like the context of the situation of like before they were incarcerated, what was a relationship like, and also kind of weighing if they are ever released, like what kind of relationship does that child want to have with that parent. Now, if the parent is incarcerated for life, I think that's like maybe a stronger argument as to abandonment. But I think it's kind of a case-by-case basis and something that we definitely would want you to come and discuss with us if that is something that comes up in your cases. Okay. So neglect, again, this is from the Illinois Marriage and Dissolution of Marriage Act, but most of those definitions have been standardized and are across. You just have to cite to the specific statute that pertains to your case. So it's not receiving the proper or necessary support, education is required by law, or medical or other remedial care recognized under state law is necessary for a minor's well-being. And I believe Rebecca in her section of the presentation will go into more detail about what constitutes abuse, neglect, and abandonment, but this is just kind of give you an idea of how it looks like in Illinois. Okay. And I know that we have some ropes and gray folks on online who are practicing from other states. So those definitions may will definitely look different wherever you practice. So just making sure to cite to Illinois law, because all of our cases are in Illinois, but just to orient ourselves and what the definitions are. Okay. Sorry, and this also includes inadequate food, clothing, and shelter, and abandoned by his or her parents is also considered neglect. So usually if there is abandonment, there's also neglect. Note. Okay, so we're gonna do, again, for different folks that learn differently, we're gonna do some kind of hypotheticals, going back to law school. And so we're gonna talk about Carlos, who's 8 years old and he's from Honduras. He came to the US with his mom after his father was murdered when he was only 3 years old. He has no one left to care for him in Honduras. And because of the 2019 change in Illinois, so it's maybe not a hypothetical, we already gave you the answer right here. But luckily, because of the 2019 change in law, which expanded the definition of abandonment, he is eligible for SIJS because his father passed away. Okay, so he was able to secure a predicate order and apply for SIJS, protecting him from deportation. Sorry, we did a different training where we did do like, what do you think? Is he eligible or is he not eligible? But this is, we give you the answer, and this is actually one of our clients, which is great. So in this case, Carlos, age 8, his dad passed away when he was 3, but his memory of his dad is positive, right? He has a good memory of his dad. His mom has good memories of him. He was supportive. He was in the picture, but then he was murdered, right? So this is a situation where, the child has not been abused by this parent and was not willfully neglected by this parent, but he has been abandoned, right? He doesn't have this parent in his life who can support him and help him in life. And so luckily SIJS is available to him because of this. Yes.
So in my case, there's both abuse and death. And so if it's automatically determined there's eligibility based on death, is it still like helpful to also add in the elements of abuse prior?
Yes, and the reason being that abandonment by death is very unique to Illinois law. There are a few other states who also include it, but on the federal level, once we have to submit the application to USCIS to immigration, if we have abandonment plus something else, it reinforces the eligibility of that child. So that's why if there is abuse prior, if there is neglect prior to the passing of that parent, we would like you to include that as well. Yes.
I have a similar question. If you have abuse, abandonment, or neglect by both parents, so even though we only need one, do you include those allegations as to both parents, or is that not necessary?
We do, usually. We do weigh though, if say one parent was abusive, neglectful, and then died, and then the child lived with, say, mom, right? And then mom was abusive and neglectful. But she still kind of like calls occasionally, like, there are circumstances as to, maybe she's working on her own life or her own situation and is trying to improve and maybe come back into the child's life, and the child wants mom maybe in the picture, especially if that mom is the only family member available to, like, that they have contact with or is still alive. That's a situation where we would weigh other parent is deceased, so it's automatic, right? And we have a history of abuse and we have a history of neglect, so let's go with that, right? But there are situations where we have to weigh, availability of notice or availability of service to the living parent or publication, or if a parent is going to fight this, right? So there are cases where both parents are abusive, but we know that one parent, because of the form of abuse that they have shown, we know that if we include them in the petition, they're going to come and fight the petition, right? And they're going to want to draw this out, or not fight it in court, but may harm our child or our guardian, right? And so those are things that we weigh, but they are things that we also include in our packets, right? So if there are concerns about a parent being in the US or who has made threats to harm them or do something like that, we would have included them. But yes, I think, again, to kind of be like, we haven't had recently any issues with USCIS not finding our findings to be enough or thorough. But yes, usually if there are two parents who have been abusive, we do include both.
Thank
you. Yes.
I may be getting to this later, but I just think just because this conversation kind of highlights another really important part of the actually the statute, which is that reunification not be possible. And so if there's any chance that a child might want to reunify and have like an actual like engagement with a parent, that's another reason why not to do it against both parents.
Yes, thank you, Marian. Yes, there's the piece that you have to find reunification is not viable, right? And it is not in the best interest of the child, right? So those are conversations that we have with the client, with the minor. Specifically, your client is the guardian or parent that is seeking the predicate order in this instance, but we have to take into consideration what the minor wants. And sorry, just for those online, I haven't been checking the chat, but if you have questions or if you can't hear the question that is being asked, please let us know. I'll try to, from now on, repeat the question before answering it. I think we're okay. I don't see anything. Okay, so we'll go over to Jenny. She's 16 and she's from Guatemala. Jenny's father was an alcoholic who physically abused her mother. When Jenny was 13, her mother fled the abuse and came to the United States, leaving Jenny with her grandmother. Jenny's father saw her occasionally, but was often drunk and never provided for her. When Jenny's grandmother became too sick to care for her, Jenny came to the United States to reunite with her mother. Jenny's mother was able to file a petition for sole custody and get an order with SIJS findings showing that Jenny could not be reunified with her father due to his neglect. But does anybody see an issue with the SIJS findings that were entered? Or something that could be added?
They're just incomplete insofar as they don't include that the child experienced abuse by witnessing the abuse of the mother by the father.
Exactly, yes, thank you. So this actually was one of the findings, I believe, that was entered before we got clarification on what abuse entailed, and so this is one of our older cases. But if that law had been in place, we could have also included that abuse by her witnessing her father abuse her mother. Okay.
What about abandonment?
Yeah, good question. What do you see there for abandonment, Ben?
Oh, I didn't know if you guys were going to hear me. I see that. Yeah, I mean, he saw her occasionally. So I guess we would need to know more about how occasionally, and then whether what's happened recently. Like, is he? I guess part of it is a question: does her like moving to the United States and now she's probably not seeing her father occasionally qualify her based on abandonment?
Good question.
I think it does. So I think it does as well. I think in this instance, I think there was more frequent contact. I'm sorry. Those online, can you guys still see the screen?
Yes.
Ben?
Yes.
Okay. Sorry, I think it might just be on our end. Okay. Yes. So how much contact did she have by dad, right? We have to establish what occasional means and what type of contact. I think abandonment really entails kind of having like no contact or not having any interest in the reasonable care of the child. Abandonment can include neglect, but neglect is separate, right? Neglect includes not providing for the child, not providing resources for the child, not, medical care, education, financial resources, versus abandonment is like no contact, no checking in on the child, not being in the picture. So if it's like once every 5 years, this person calls and on their birthday and is like, hi, hello, 5 minutes, and then it's over. I think an argument for abandonment can, but we would have to kind of weigh it, especially in this situation where abuse is there and neglect is there.
Just a quick follow-up. Does Illinois, I don't know this, but does Illinois law have any like time definition as part of the abandonment? Like if there has been no contact for a year or 6 months or anything like that? That's how it is in other
No,
states.
but I think it would have to be kind of like consistently not in the picture, right? So again, like if they've been in a picture every 5 years, they kind of remember that they have a kid. You can include all 15 years of that child's life instead of the last contact 5 years ago.
It's a reasonableness standard.
Yeah.
So
Yeah.
failure to maintain a reasonable degree of interest, concern, or involvement in the child's welfare.
Yeah, and typically in the cases that we see, we're looking at periods of years. We're not usually analyzing well, is 6 weeks enough? Is 6 months enough? We're usually looking at situations involving a longer period of time.
Great. Thank you. Okay, and our last case sample is Raymond. He's 18 from Haiti. And Raymond's parents were physically abusive to him from a young age. They beat him and withheld food as punishment, and Raymond eventually ran away and lived on the streets in his home country. Raymond came to the US as a teenager and moved in with a family friend who treated him like family. Although Raymond is now 18, his family friend was able to petition for a post-18 guardianship over him and seek findings that he cannot be reunified with his parents due to their abuse, and that it is not in his best interest to return to his home country. So Raymond is actually a great example of somebody who would not have benefited back before 2021. And this is a prime example of a child, a minor, who desperately needed some type of support and status and work permit and stability. But because he was 18, he would not have been eligible. But luckily he now is, and he was. And so this highlights that specifically, that the expansion of 18 to 21, but also what constitutes abuse, right? So his parents would withhold food as punishment, and they would also beat him. So in the US, it's very commonplace that physical beatings is not allowed, but in a lot of other countries it is. And so we do have to weigh that a little bit, culturally sensitive of like, what is, what is something that is culturally something that's allowed or expected. And sometimes we have come across clients who are like, well, yeah, they like physically beat me, but that's fine, it wasn't abusive. Or like, it was fine, my parents didn't hurt me, they never, and it's kind of diving into that a little bit sometimes. A lot of our kids, kids love their parents, even if their parents have been abusive a lot of times. And so it's partly kind of balancing wanting to help them, but also kind of recognizing that this is their life and their lived experiences. But in this instance, it's very clearly, this isn't, to fix some type of behavior, and it is not reasonable, is the standard.
I want to be clear too, like it's important to have these conversations with the child, and we do that when we screen, and to be culturally sensitive and obviously get the child's consent to go forward with allegations like this. But what applies is Illinois law. So it doesn't matter to us if in Haiti or in Guatemala or whatever country they come from, whatever was done to them was legal. We are applying Illinois law in these cases. And some of that can allow us to have a more sensitive conversation with the child as well, recognizing like this was your relationship, you have agency in these cases, but what we want to explain to you is legally under Illinois state law, here's what you qualify for and why, here's how the law would classify what happened to you. And that allows us to give a little bit of distance and a little bit less judgment to kind of work with those clients. But we are always following the state law with respect to those definitions.
So we talked about on our timeline of how long these cases take for them to be able to get residency. My Kansas accent came out of some. I'm so sorry. And so again, just visual learners, this is the current visa bulletin. So this is where our clients, once they're granted SIJS status and they're in line for a visa to then become residents, could check or on our end, NIJC is where we would check the delays. So currently, the SIJS is in the 4th category, and their priority date is based on when they filed their initial petition. So currently, immigration is currently processing applications from December 2019 for residency. So, that's our 4-year kind of delay right now. Sometimes the visa, it updates monthly. Sometimes it jumps 3 months, and sometimes it stays there. So that's why we say it's about 4 years.
Or sometimes it retrogress.
Yes, they suddenly get a big influx of applications. They're like, hold on, we have too many. But we have seen a good amount of jumps in the past few months. I think 3 months ago, we were at April of 2019. And so now that we're in December 2019, it seems like it's going well. So, but we want to caution our clients still to be thinking 4 years for right now. Okay, this is recent SIJS regulations. They were enacted in 2022. Again, this is just for your information. But if questions come up in your client, you're not quite sure how to inform your client, you can let us know. But essentially, USCIS would sometimes send us a request for evidence, kind of questioning the judge's order. They would want more information about why the judge found that the child had been abused, abandoned, and neglected. And so we really pushed back, the immigration practitioners pushed back and said, judges, state court judges handle state law, you handle the federal side. So if a judge has entered an order, that means that they found enough there to be able to enter those findings. And so luckily USCIS backed down, immigration backed down and said, okay, we can't question the judge's order. We have issues about fraud or something else, we can push on the other end. So this is really great. So as long as the judge signs that order, we're good to go, essentially. Okay. And see, so it does clarify some points about what parental maltreatment can include. Includes court-ordered custodial placements and court-ordered dependency on the court for the provision of child and welfare services. So this, it kind of includes to expand children who are in, for example, DCFS care, who also are abandoned and abused by biological parents, but who can then be eligible because they've continued abuse or neglect or abandonment. And it removes marriage as a basis for automatic revocation. So, and this is very technical, but it was kind of unclear. The statute says that the child has to be under 21 and unmarried. And so a lot of clients, we used to tell them they couldn't get married until they were residents, which is a really long time. As I mentioned, it could be 4 or 5 years. And especially if it's like a 17-year-old, 18-year-old, 4 years from now, they're 22, 23. And some people would want to start their lives and kind of put this behind them. And so USCIS clarified that the moment that they submit their application and they're approved, which is about 3 to 6 months, they have to remain unmarried. Once they're approved, they can go on with their lives, which again is a great benefit to our clients. Okay. And then our last slide, again, visual learners, just deferred action. So if we get that predicate order, we submit that SIJS application and that application is approved, their approval notice comes with deferred action. And so really happy that it includes this. And deferred action is just an act of prosecutorial discretion that defers proceedings to remove a non-citizen from the US for a certain period of time. So it does not provide lawful status, but it does allow those with deferred action to obtain employment authorization. So for those who are non-immigration practitioners, a big group of people who have deferred action are like DACA folks. Okay. I mentioned briefly that we would want to hopefully get these in before elections happen. And that's because if they are approved, we can then, if any of your kids are in proceedings, if they are currently in removal proceedings, which will have been noted in your packets, this is a grant of SIJS, and getting a grant of deferred action is enough basis to get them out of court, which is a big thing. We want to get them out of court out of proceedings so that if a new administration decides, well, you're 4 years waiting for a visa, doesn't mean that you actually, so if you're waiting for 4 years for residency, that means you don't actually have something permanent here. And so we'd rather get them out sooner rather than later. Okay, any questions before I hand it off to Rebecca? Okay, great. We'll also have a Q&A at the end, and we'll also be going around and talking to everybody with their cases if there's any case specific questions as well. Okay. So I'm going to pass it over to the state court process, going into more detail about what you should expect, how to file, to do draft, notice, service, publication, all that stuff, to our expert, Rebecca from CBS.
Here's some button to advance. Yeah. Okay. Great.
Everyone, I can do.
That's okay. Thank you. Hi, everyone. I'm Rebecca Rashid Farogi. I'm from Chicago Volunteer Legal Services, also known as CVLS. Just for my own reference, since I don't know everyone in the room, can you raise your hand if you are from Ropes and Gray? Okay. And then if you're from the NIJC? And if you're from neither one of those? You're in the wrong room. Okay. So great. Then nice to meet all of you. Thanks for having us. I think Berenice and Dominique have already explained that this is a partnership between the NIJC and CVLS. And I really love this program because it allows all of us to do what we do best. So CVLS, as some of you may know, if you've been involved in any of our other pro bono work, or if you come to Res Judicata, We are a legal aid organization here in Chicago. We basically do what the NIJC does, except on the civil side. So we're in state court doing family law, guardianships, adoptions, civil litigation, all on the civil side and almost all at the Daily Center, which is what you all will be doing soon. So if you're typically a federal practitioner and this is your first experience with state court, I'm sorry. It is a messy world and a very, very different dynamic, which you will soon experience. But we are so thrilled to have you. And like I said, we really love this partnership because CVLS advises on the state court side of things. So you will have, most of you have a guardianship. I think there's one domestic case in the packet. Is that right?
I think so.
Yeah. So I work on the guardianship side. I'm the director of our guardianship program for minors. And then we have two other staff members, Phil and Rob, who work specifically on the domestic relations side. And so we are here alongside the NIJC to walk with you through your case from beginning to end and help you troubleshoot, review your documents, and provide support during your case. So we are the ones who are in these state courtrooms every day doing guardianships and divorces. And so really these cases are starting off with a state court case. They're really not much different from a regular guardianship for a non-immigrant child. If I'm a grandmother taking care of my nephew because his parents are deceased, I need to go into this same courtroom in front of the same judge to get guardianship of him. So these are really state court cases with an immigration twist. And so we feel well equipped to work with you on these since we file these guardianships and adoptions and custody cases every day. So we're going to talk a little bit about what that state court piece looks like. And I'm hope to give you some practical information about what this is going to look like for you in actually filing and doing a guardianship or a custody case. This is kind of a long training, so feel free to interrupt me with questions. We love for it to be interactive. Stand up and stretch your legs if you need to, or if you need to use the restroom, because I know we're in here for a little while. So these are the steps to obtain a predicate order. So first, obviously, you're going to review the case file. All of you have received, you've been assigned to a specific case. You've received, I see some of these in front of you. I've seen birth certificates, I see papers with regard to your specific cases. So you're going to look over those, review them, familiarize yourself with the case and the facts, and then you're going to speak with your client. So you want to reach out to the client, introduce yourselves, let them know that you're going to be the one handling the case. They may have spoken to several people before this case gets to you. They get screened by the NIJC. Somebody else may call them to collect information or to clear up any details or to ask them for a copy of the birth certificate. So they may have talked to a number of people, and then in some of our cases, CVLS may have talked to them for some reason. So make sure to explain who you are. They might have other legal matters going on. Some of them are in removal proceedings, so it's confusing to somebody who is perhaps unfamiliar with the legal process. So let them know who you are. And then what we're really looking for more than like a formal interview of the client is really just, at least from my perspective, touching base, introducing yourselves, getting to know them and letting them know that you're going to get to work. And then the most important next step is just to get to work on drafting the documents. So state court practice is really a lot of paperwork, which may be the same for you in your day jobs, but a guardianship or a custody case is, we need these 10 documents to get this case done. And a lot of them are just court templates that are not very difficult to fill out. And this is the same is true for a guardianship or a custody case. In Illinois, the term custody is no longer used. We're now talking about APR, which is allocation of parental responsibilities, but nobody wants to say that because it's a mouthful. It's kind of ridiculous. So I'm going to continue to say custody, but just know that term technically, legally doesn't exist anymore. So we're going to start to get to work pretty quickly as you can, drafting some of those documents and preparing them. Then we're going to send notice to, or service to the people who are entitled to notice. So this is a little bit different in guardianship and domestic relations cases. I'll talk about that later. But effectively, if you're asking for guardianship or custody of a child, you got to let somebody know. You can't do that without letting the parents know, letting close family members know, and in guardianship cases, adult siblings of the child, which I'll get into. Then we're going to schedule a final hearing. We'll prepare the client's testimony, and you'll end up with a state court order with these special SIJS findings at the end of your case. If you have all of your ducks in a row and you are very organized and efficient, and your clients are responsive and do what they need to do, you may be done with your case in one court hearing, or maybe two in a custody case. So these are not litigation heavy. These are all uncontested cases. You are going to be, at least for Cook County, I'm not entirely sure about DuPage, appearing on Zoom. Do you know, Hillary?
I don't
DuPage
know.
was on
I
Zoom?
think it's Zoom,
Okay,
but I couldn't swear to that.
that's okay. So if everything goes really well, 2 court appearances max. So these are not really litigation heavy. Again, it's really more about the paperwork and the documents you need and making sure you file things on time and moving things efficiently through a timeline. So we're going to go through each of these steps individually. So we're going to meet with our client. NIJC has already mentioned that your client is the petitioning parent or guardian. Volunteers sometimes find this confusing. We're obviously doing these cases for the benefit of a child, but we have to represent an adult petitioner as our client. So in your state court predicate order case, your client is the petitioner for guardianship or the parent petitioning for custody. If necessary, meet with the child separately to preserve trust and confidentiality. This is especially true with older children. You don't need to be meeting individually with young minors if you have them in your cases, but certainly for kids who are older, teenagers, and in particular, especially in probate cases, children 14 and older are kind of given a little more say-so in their cases and have the ability to nominate their guardian. So if you have a teenager, you may want to speak with that child separately. Review all your information with the client before filing anything in court. So make sure they understand what the filing says, go over it with them in their native language. Working with an interpreter to ensure that the client understands the contents of the petition and the process, and then discuss any risks with family members before filing in state court. So many of our immigrant families, understandably, are going to ask about any risks to them in terms of, their immigration status. And the NIJC is better equipped to answer this than I am, but we can never guarantee that anything is completely risk-free. But at least in our experience of doing these over many years, we've never actually seen a single instance of someone being detained at court or, anything being shared with the immigration authorities. We're going to court on Zoom, so they never actually have to, at least in Cook County, have to set foot in the courthouse, which I think many people find reassuring. At least they will need to go probably get fingerprinted there, but they're probably not in a courtroom appearing in front of a judge in person. So again, not 100% guaranteed, but very, very low risk from our perspective.
And we've screened clients and had those conversations with them already.
Okay.
But as Rebecca said, the process is confusing. They've talked to a million people, all of their questions, they will probably ask you all of the same questions again, which is fine. But if there's anything that you are not sure about or not comfortable advising on in terms of immigration specific consequences, you can definitely reach back out to us.
Okay, thank you. So what kind of case do you file? This is not something you need to figure out. Your packet already tells you whether you have a guardianship or a custody case, but just so that you understand the difference. An SIJS predicate order may be obtained as the result of a case in which a court places the child in the custody of a person or an agency. So there are cases where children are in the child welfare system and they're placed in the custody of an agency. We are all working on state court cases that are outside of the juvenile court. So we're all placing children in the custody of an individual. The court does not need to make a separate finding of being dependent on the court if it's already entering a custody or guardianship order, again, because we're placing the child with an individual and not with an agency. So the most common types of cases are custody and guardianship cases, but as NIJC has already mentioned, this can also include adoptions, juvenile dependency, and delinquency cases. So you are either filing a probate guardianship or a custody case. And so in custody cases, the children are with a parent. So child is living here with mom or dad, or in a guardianship case, they're living with a non-parent. The exception to that rule is when the child is 18 or older, those all become guardianship cases. So if you have an 18-year-old, 19-year-old, 20-year-old, even if they're living with a parent, that's going to be a guardianship case because the Probate Act is the one that carves out that 18 to 21 provision. So filing and fees, e-filing is mandatory in Illinois civil courts now. E-filing is not difficult. CVLS has guides on how to do this, at least for the Cook County cases. NIJC and the CVLS use Odyssey e-file as our e-filing system, which is free. If your firm uses something else, it's perfectly fine to use any kind of Illinois e-filing system is fine. There are several. We all use the free one because we're nonprofit organizations, but you may have other access. So to e-file a case, you can use a CLSP waiver. CLSP is a civil legal service provider form. That's a very simple template form that you will fill out saying that your client meets the low income guidelines for having their fees waived, and you will file it using a waiver account. If you don't know how to do this, CVLS can provide you with information on that, but usually at a firm, there's somebody who can help you with this and can do this for you. CVLS and NIJC, again, are considered civil legal service providers. So we have the CLSP form, which enables the parties to file for free. We don't really need to go over this. So guardianship cases, as I mentioned, are typically filed by a non-parent. Again, the exception is for those post-18 guardianships. Those are all going to be guardianships, whether or not the child is living with a parent. Guardianship cases are covered by the Illinois Probate Act. So when you reference the law in a guardianship case, you're going to be referencing the Probate Act. Again, NIJC has an extensive website where you're going to find very helpful samples with that case citation already plugged in. So you do not need to be finding all of this on your own. But just so that you know, guardianship cases are governed by the Probate Act, and domestic relations fall under a different act. This meets the custody requirements of the INA because you're placing the child in the custody of an individual. What is guardianship? Guardianship is something that's not familiar to a lot of people. It's somewhat rare in the legal world, but guardianship gives a non-parent daily decision-making authority over a child. In a guardianship case, parental rights are not terminated. So if your clients ask you about this or are curious about what the ramifications are for the parents, technically their parental rights are not terminated, and a guardianship can be undone in the future. The parents, in theory, it's very unlikely in these cases, but in theory, the parents could come back and petition the court to discharge the guardianship at any time. In Cook County, guardianship cases are heard in the probate court, and in other counties, I'm not sure about DuPage, but in other counties, custody and guardianship cases may be heard in front of the same judge because they're just smaller jurisdictions where they have judges who hear a variety of cases. In Cook County, we're huge. We have thousands and thousands of cases, and it would be impossible for judges to handle cases across divisions. So we have a specific division for domestic relations that only hears those, and we have probate that only hears guardianships. Who can be a guardian in Illinois? The NIJC has already screened for this, so you don't need to be asking these questions, but just so you know for your own reference, a guardian needs to be at least 18 years of age. In the cases where you have a post-18 quote unquote minor, the guardian needs to be 21 in those cases, because we didn't want a situation where like a 20-year-old was having guardianship of a 19-year-old. So that's the requirement for those. But in general, at least 18, they need to be a resident of the United States. This has an asterisk because this only means they need to live in the United States. It does not mean that they need to have legal status. There have been some judges who have tried to impose an immigration component here, but the statute just says a resident of the United States with a lowercase r. So just in case you were ever to have a judge question that, you can gently, tactfully remind them that the statute just says lowercase resident. And in Cook County, the judges know of this history of potential conflict, and they will often even ask, do you live in the United States? Instead of asking the clients, are you a resident of the United States? You need to be of sound mind and not adjudicated disabled by a court. This does not refer to Social Security disability. This is talking about guardianship of an adult who doesn't have mental capacity. So you need to be somebody who's capable of making decisions, not adjudicated disabled by a court of law, not convicted of a felony. This is actually not entirely true. You can have a felony conviction on your record and still become a guardian of a child. But this is on a case-by-case basis, and it needs to be ideally something that was a long time ago and did not involve any harm to a child. If you have a felony on your record that involved harm or threat to a child, that's obviously, for obvious reasons, an automatic bar to getting guardianship of a child. Tony?
For residency, does living in the US have a length requirement?
That's a good question. It needs to be your primary place of residence, and you need to be able to show that you live in the United States. So most of our petitioners will have some sort of ID that lists Chicago as their place of residence. If they don't, the judge will definitely have questions about that. And they'll need to put their address on the petition. So if they were to show up with some other address on there, that would certainly be a problem.
What are I know that I have several clients who would not have their address on like a form of identification. Like what could they actually do to demonstrate that they are residents of that place?
The court usually doesn't bring it up, but they're gonna need to put an Illinois address on the petition or Cook County address on the petition. So the judge is gonna be looking for that. I think the judge doesn't necessarily verify that. I think that the NIJC has screened the families for residency requirements.
Well, I think that the question though is a good one because we've seen judges ask for identification, not just judges in Cook County, for example, if you have to get fingerprinted. So if there are issues with either the petitioner or other adults in the home not having any form of ID whatsoever, even ID from home country, we'll talk to you all about like how we can figure that out. The judge in the courtroom in Cook County is not asking the individuals to like show ID at the hearing. But as Rebecca said, they need to live here. They need to have the intent to continue to live here.
And they will have to swear under oath that they are a resident of the United States.
But they don't bring up, for example, the UCCJEA and like ask them, have you been here for 6 months?
Right.
For example. So we do have some recent or relatively recent arrivals. And in our position basically is that if those kids and their caregivers are here and they intend to be here and there's no other court in another country with jurisdiction over them, they should be fine to proceed, but they do have to like affirm their intent to continue to live here. But the ID question actually is one that I see as being a little stickier, and we've been dealing with it on a case by case basis, and we'll talk to you about what to do if it becomes an issue.
Right. So to answer your question, Tony, it's usually like they're looking at 6 months, but nobody is asking. And if there's no conflict about what state has jurisdiction, then nobody is really asking.
I think that's where it hasn't come up. We don't have to affirmatively make it an issue.
So what documents are you going to need for a guardianship? You're going to need the child's birth certificate. I see some across the table, so hopefully all of you have those. And if you don't, that's something that you can request from the family. If the parents are deceased, in a perfect world, we would have a death certificate. So if you are going to claim abandonment via death, you have to have a death certificate. It's not enough to just say that the person is dead. You can, but then you're still going to need to publish a notice to that person. So super important. If you're doing abandonment via death, you need a death certificate. If you don't have a death certificate, you're still going to send notice to the deceased person just to cover all of our bases because the judge doesn't have any proof that that person is dead. Does that make sense? Okay. Great. And we will file the death certificate as well. All of these will get e-filed into the case. We are going to want a photo ID of the proposed guardian. It can be any official photo ID. It does not have to be an Illinois valid driver's license. It can be a passport. It can be a matricula. It can be anything. And then normally the child must be in the guardian's physical custody. This is for standing requirements under the Probate Act. If you have a situation where the minor for some reason is not living with the proposed guardian, you can talk to NIJC and CVLS about those. There are some circumstances that are still okay. For example, if the person is already over 18 and they're working and they have their own place, or if they're, we did one recently for a college student. I mean, obviously, people have different circumstances and they may still need a guardian even if they are in this situation or even over the age of 18. So just talk to us if any questions about that come up, but the default is that they should be living with the person petitioning. So the next step is to draft and file the pleadings. We've talked about e-filing instructions and the CLSP waiver. The petition and the final order should always keep in mind, again, this magic language, we're going to mention this several times throughout the training. 3 magic things, right? Reunification with their parent or parents is not viable due to abuse, abandonment, or neglect under Illinois law, and we're citing to the appropriate definition. And then that it would not be in the child's best interest to return to their home country. So one question that we get all the time, and that you will get probably in your case, is what is going to happen at court? So we'll get to this a little bit later, but you will talk to your clients about what this state court hearing will look like. And it's important to ease the family's nerves, to let them know that this is not an immigration proceeding, and the judges don't care about their, not that they don't care, but it's not relevant, their immigration journey, their status in the United States. The court is really looking for, does this person qualify as a legal guardian? So when this says it is not in the best interest of a child to return to the home country, if any of you have ever, I know maybe nobody raised their hand saying that they've never worked on immigration cases before, but this is not like an asylum case where you need reports on country conditions and you need to bring an expert witness to show that the child shouldn't have to return to Honduras. The judge is going to know that it's not in the best interest of the child to return to home country. Otherwise, we wouldn't be here. And she will not be asking questions about that. She will not ask questions about how did you get here and did you cross the border and did you enter legally or illegally or any of those things. They're really looking for, is this an appropriate guardianship case? Is this an appropriate custody case? Oh, I don't know what's happening.
I think somebody in the other chat or like in on the Zoom call,
Oh,
but it should be good.
it's still working?
Yeah, it's still working.
Okay. So we're going to talk a little bit about notice. I mentioned that when you file a case involving a child, you're asking to appoint a guardian or a custodian of a child. We need to send notice to the people who under the law are required to receive it. You wouldn't want somebody to file for guardianship of your child, not let you know, right? So there's a list of people who are entitled to receive notice under the law. And this is one way in which guardianship and domestic cases differ. So in a guardianship case, you merely need to send notice. The requirement is just to notify. This can be done through mail or through publication. And what is going on with this thing? Oh, no. And then we need service in domestic relations cases, but realistically, in most of these cases, the parents are living in home country with some exceptions. And so we will still be, in most cases, using publication to send notice to the parents, even in those domestic relations cases. So our options to provide notice in a guardianship case, which most of you have, are a trackable mail, so return receipt. So we're talking about, certified mail if they live in the United States, FedEx, DHL, things like that. Something that you can confirm delivery and you can track online to show the court that it was received. You can also do this via an appearance and consent, but this form has to be signed and notarized. So this comes up a lot. So if you have a parent who's in the picture, the child is in contact with mom or dad, and they're in agreement with the guardianship, a lot of people say, well, I can get a consent. Since the consent has to be notarized, this is kind of an onerous thing in most countries. So it's not like a notary here where you go and pay $2 at the currency exchange. Like you actually have to go, and it's expensive and it's cumbersome, and most families are not going to be able to get a consent notarized in where they live in home country. So we're usually not going to encounter this unless they're here in the United States.
Is that a Cook County requirement or is that a state law requirement?
That's a
I was
state, yeah.
Helping somebody with a case where they just had the parent sign. and
Oh,
it
really?
wasn't Required to be noticed.
I thought it was a county requirement.
To have it notarized?
Yeah, I didn't see it. I mean, if it's statutory, I wasn't aware of it. I thought it was a
Because
Judge Alonso requirement.
I don't know. It's a Cook County court form, the oath and bond. But
Right.
I don't know I actually don't know whether I really only work in Cook County, and I couldn't tell you whether for the DuPage cases, you will need notarization or not. But we can find that easily because we, between our organizations, have done several DuPage cases, but I would have to look it up.
We do think, I think it's kind of like county specific, like some counties do, sometimes don't. I think kind of, it also could be judge specific as well.
Yeah.
And the open bottom is different than the, like the parents and consent, right? Or you're saying if parents consent, they need to sign off on that open bottom.
Yeah. Yeah.
The second.
What?
This is technical.
Oh, it is, yes. So there are two potential forms that have to be notarized. But if a parent is consenting, at least in Cook County, to the guardianship, that form needs to be notarized. So you're almost never going to have that unless they happen to be here. And we do see that sometimes. So if the parents are in the United States and they can get a consent notarized, then that's great. More than likely, you're going to be working with publication in your case. So we're going to be sending notice via publication. Does everybody know what that is or what that means? A lot of people nodding their heads. Yes. Okay. So we're going to be sending publication in a newspaper that nobody reads, but that fulfills the obligations to send notice by publication. Or if you have a death certificate, I mentioned this before, if you don't have a death certificate, you've got to send notice. If you do have it, we're going to file that along with an English translation. Background checks. So Hillary mentioned things that are judge specific or county specific, and this is one of them, and this is a big one. So if you are in Cook County with a guardianship case, which a lot of you are, all adults in the home, so the petitioner and all adults in the home must undergo 2 background checks. One is CANTS, C-A-N-T-S, which is the Child Abuse and Neglect Tracking System. This is a DCFS background check. And they also need to have a criminal background check via fingerprints. So they have to get fingerprinted, and those fingerprints have to be submitted to the court for a full FBI background check. This is Cook County specific, although somebody was talking about recently Lake County doing this. Have you heard that? Or okay, I don't think anybody here has a Lake County case, but it hopefully does not apply to DuPage County. But this is a pretty cumbersome thing. So remember, not just the petitioner, everybody over 18 in the home. If you have a minor who is over 18, this does not apply to them. So the minor, even though they're over 18, doesn't also need to go and get fingerprinted because they're considered a minor for the purposes of these proceedings. They have 2 options for the fingerprint background check. We're going to send you all this information, but they can go get it done for free at the Daily Center, or they can go to a private provider that might be closer to home, but they have to pay. And it's not cheap. It's probably about $60 a person. And that can really add up if they have multiple adults in their home. So just know that the Daily Center is the free choice. You will need a court order giving them a free background check at the Daily Center, and we will give you all that information. It's a really simple process. We just email it to the court and they enter it. Yeah.
So I want to jump in to say that we have noticed recently that sometimes there are delays related to these background checks.
Yeah.
So just want to emphasize the background checks are like number 2 thing that you do in the case. It should not be like the thing that you're thinking of the week before the hearing, because getting the order from the judge, getting the clients to the Daily Center, getting them fingerprinted, and then getting the signed forms back and the background check run with the court can all take several weeks.
Yeah.
Last time I was in court before Judge Alonso, she cited like 2 months, which I think is maybe a bit
Conservative.
that's very conservative, but still this should be like the second thing on your to-do list in terms of preparing the case, like getting those background checks taken care of. We've had a couple of cases now recently where like the very last minute there was an issue with the background check and we've had to continue it.
Yeah.
So we're trying to really highlight that for our new cases.
Yeah.
Like those take a long time, get them started.
Super, super important point. This is the #1 cause of delays in the cases that we see in probate, the background checks, for the reasons that Hillary mentioned. So if you have a probate guardianship in Cook County, I would encourage you to think about the background check process running concurrently with publication. So your publication is going to take about 40 days or 3-4 weeks-ish to run. And you need to have that window running between when you file and your first court date. I don't know if this makes sense, but let's say I file my case today. I get a court date that is 5 weeks from now. I need to send notice to the other parent, and this kid has 4 adult siblings in Honduras, and I need to publish to all of them. I need to publish now so that my publication window, which is roughly 35-40 days, runs between now, my date of filing, and my court case that's 5 weeks from now. If I wait to publish, I'm not going to have the sufficient publication window run before my court date, and the judge won't be able to give me my order on that court date. So I would, on top of that, I would encourage you to think about the background check process needing about that much time too. So I need to get these people to go get fingerprinted and to send in the CANS form now, when I'm filing, again, so that by the time I get to my court date 5 weeks from now, the court has all of those results. Does that make sense? Okay, Tony.
Just confirming, so if it's in domestic relations, parent doesn't need to undergo CANS or criminal background, but if the
Correct.
kid's 18, then that parent does.
Correct.
Okay.
Yes. Yes.
For the criminal background checks, are those checking for any criminal history or other issues in the United States? Or like
Yes.
if there's an adult in the home that potentially has issues in home country, it won't pick up on that?
I don't think so, no.
Okay, I assume.
It is nationwide. I mean, it is a full FBI. It will be state and federal, but it's limited to the US, yeah.
Okay.
They will be asked under oath, of course, have you been convicted of a felony?
Right.
Of course, like who knows whether it's like a felony in their country or whatever, but
Right.
yeah, if they have some sort of like severe issue on their record and you've encountered that when you speak with them, please come talk to us about that.
I was thinking, I have a case that's not relevant to today, but I have other adults in the home that potentially have criminal history, which is.
Okay. Okay, good questions. So communication with the immigration attorney, and also this applies for CVLS as well. Please communicate with us and collaborate with us on your case. We are here to support you. We want to take a look at your documents before you file them. We are here to answer any questions. And I think that the NIJC and CVLS both really have a dynamic of providing very hands-on support to our volunteers. So any questions you need, please come see us. And we want to work with you on these and walk alongside you through the case. Have the immigration attorney review and approve the final order. These are super important. So the only things that you will really end up drafting on your own are the petition itself and the order. So the things that you're asking the court for, we can't use the forms like the court's regular filings because we're asking for this special SIJS language. So we have to draft our own, and then the order that's going to mirror those findings. Everything else pretty much is going to be a standard court form that is used in every other guardianship and custody case out there. So preparing for the final hearing, parents and adult siblings have received notice via mail. We want to make sure again that time frame has run. We're going to have a window of publication. So when you publish, it needs to run for 3 weeks. So again, I mentioned that takes about 35 to 40 days. The law bulletin or wherever you're publishing will usually provide you with what those 3 dates are and give you kind of like a default date. And then your hearing can happen anytime after that day. Background checks need to be complete. You need to request an interpreter ahead of the hearing. We will tell you exactly how to do that. Several days prior, we need to email courtesy copies to the judge. Not sure of the exact procedures in DuPage, but in Cook County, we definitely need to email courtesy copies to our judge several days in advance and include the proposed final order. CVLS has samples of what those courtesy copy emails should look like. And the probate court does not provide a court reporter. Bring one if you need one. I don't think we typically do that unless we have a very unique issue that we're concerned about, right? Okay.
And that would have been flagged for anybody who took on a case.
Yeah. Guardianship hearings in Cook County are held via Zoom. We will give you all this information. There's only one judge. So in Cook County, guardianships are all heard in 1806 of the Daly Center. Again, they're on Zoom, but they're in theory happening in room 1806 of the Daly Center with Judge Amy Alonzo. One judge, we know her really well. We're in front of her every day. She's very familiar with these cases and friendly to these cases. On that note, if you have a Cook County guardianship, you don't need to be filing a memorandum of law. So in your packet, it will have, various documents that you're supposed to be filing, one of them being a memorandum of law saying what SIJS is and why the court has to enter it and blah, blah, blah. You do not need to do that if you're in Cook County with a guardianship case because Judge Alonzo knows these cases very well and we just don't need that. So you can skip that step. Talk to your client ahead of time about what to expect. Again, the court is going to be focusing on the state court aspect only and not their immigration matter. And if all goes well, you may have one court case or two court cases at the most, hopefully. Again, the Cook County judge is familiar with these, and a lot of the domestic relations judges are too. There are many more domestic judges. There are probably 40 of them, so it's just a much bigger division. But we're getting around because we file so many of these. So I'd say the vast majority of the domestic judges have seen one of these or at least know what they are. Post-18 guardianships, we've already talked about this, so I'm not going to go over it in detail, but they allow for a minor who is over the age of 18 to still apply for SIJS up until the age of 21, bringing our state law into compliance with federal law. Same forms, same process, but we should just make sure that you reference and cite the post-18 language in the statute. So when you go to the NIJC's website that has all of these templates, if you have a post-18 case, make sure you're looking at the post-18 samples because those are specific to post-18 cases. And then custody and APR cases also meet the custody requirements. We talked about this already. Allocation of parental responsibilities is the technical term, so that's what your petition is going to say. And these are governed by a different statute, the Illinois Marriage and Dissolution Act or the Parentage Act. These can be filed alone or as part of a divorce. So you can ask for custody of a kid even if you're not getting divorced, or you can do it in conjunction with a divorce. Yeah.
Can they get divorced if the other parent is in home country?
Yes, and I don't know if there are some of those in your case file, but this would be a default divorce. So you're asking the court to allow you to get divorced even though the other person is not involved in the case and may be MIA. And yes, absolutely, that can be done. I don't know if any of these are divorce cases.
Sometimes
Yes, you can. People do it all the time. All right, so drafting the petition, I've already mentioned a lot of these things. I'm going to go quickly over them, but the pleadings are standard court forms. They need to allege facts sufficient to support parental abuse, abandonment, or neglect, include the request for SIJS findings, and avoid any mention of the parents or sponsors' involvement in the child's journey to the US. I think this is important. So a lot of volunteers will look to include a lot of information in the petition about the family's immigration situation, what happened to them in home country, why they fled home country, their immigration details, et cetera, how they entered the United States. I would say, and I'll let the NIJC speak to this because they're the immigration experts, but as a general rule, less is more. We want enough to meet the requirements to allege abandonment or abuse, but we don't want to include so much that we may cause problems with the immigration cases that the family may have going on, or have now a very detailed record of something that might contradict what is written in their asylum case or something else. I don't know if you have anything to add.
Additionally, I think just kind of keeping in mind that this is, all of these filings are going to be public or can be public. And so although we do want to allege the sufficient facts to meet the standard, we also don't want to put everybody's business out there, right? And like for that reason, and also for the continued immigration case, we don't want to provide details that because of trauma or otherwise that just contradict later on. And to that point, we don't put status of sponsors or guardians in anywhere in the petition. It's not necessary, it's not required, and please do not include that in there.
Immigration status.
Immigration status, sorry, yes.
We're not going to talk about this magic language again, but these are these three super important things that need to be in both your petition and most specifically in the last section of your final order, because that's why we're here, is to get in a predicate order that has these specific findings in them. We've talked a lot about abuse, abandonment, and neglect, and I think that we are over time, so I'm going to skip over these. We've talked also already about personal service versus publication. You can talk to CVLS and the NIJC about whether you need to be obtaining personal service or whether you're going to be looking at a situation involving publication. Most of you are going to be publishing. So just if you have any questions about that, please speak to us. We're not going to go through this. It's really boring and not necessary. So we've talked about the guardianship cases mostly. I think there's one domestic case here, so I'm not going to go into too much detail. The domestic process is slightly different. So instead of just having your final hearing in front of the judge, you're going to need to move to default the responding party, so the mother or the father or both, if they are usually the father, but sometimes not, is the person who is not responding and is not going to be involved. We have to find them in default. They got notice, they didn't show up. Court, please find them to be in default. So we need to have I mentioned that those cases are going to involve 2 court appearances. This is going to be one of them where you say, hey, judge, I sent notice, I did it right. The person isn't responding. Please let us proceed without them. I'm going to find them in default. So you will move to default and get that order. And then you'll move on to the final hearing, which in a custody case is called a prove up. But it's really just a court hearing where you're going to be asking your client some questions in front of the judge. But same thing, drafting the final order. Again, you're going to draft this in both types of cases, again, with this same magic language. And same thing for these cases too. Please communicate with CVLS about your state court case. Make sure that both of us, we'll all be copied on the same email. So these are not separate processes. When you send it to us, I'll be on there and NIJC will be on there. And we will review for both the family law side and the immigration side. Tony.
Rebecca, would you go back like 2 slides? So the APR page. Yeah.
This?
No, well, yeah. So if you're in domestic relations and other parent is in home country, so you serve by publication.
Yes.
Like then I still do this certificate in motion?
Yes. Yeah. You say, hey, I sent them notice in the Chicago Daily Law Bulletin that nobody reads and they didn't respond. So now they're in default. Please give me my default order. Same process. So no matter where they are, you have to find them in default if you're, unless they're going to participate, but that doesn't ever happen in these cases. So.
And then 30 days after service, does that mean like 30 days after the final like thing was run in the law bulletin?
After the beginning of when it was run.
The first.
Yeah, so remember I mentioned publication takes 35-ish to 40 days. That's that same time period here.
Okay.
So after that period has run, then you can move to find them in default.
Okay.
So the domestic relations cases take slightly longer because you have to go through this process and then file a motion for prove up, but not really that much longer. It's a very similar process. You just need that one extra step.
Can I also just clarify those that are on the kids team, we also would need to see your drafts and petitions and orders before you file them. So you'll be assigned the technical support attorney too.
And then this is wrapping up the state court part. So this talks about the immigration process. I think we've already addressed that after the state court predicate order, NIJC is taking these cases back to do the SIJS application. So your work is done at that point, but it is the beginning of a long road, which is what this next slide says. And we've already talked about this, about the timeline and what comes next. But I don't want to prevent everyone from eating lunch because I think we already have a pretty short lunch break. So any questions about the state court side of things? The domestic relations cases may have some additional documents that you need to file in terms of one is maybe an affidavit of military service where you're saying that the respondent is not an active member of the US military, things like that. But those are all court form templates that you simply fill in. And it's not a particularly burdensome process. We will provide you with all of that. Yes.
Both background checks you said can be gotten for free at the Daily Center, or is it just?
Yes.
Okay.
Yes, both can, if they go to the Daily Center to get fingerprinted, those are free. CANCE is free for everyone.
Okay.
Yeah, and you don't need that in domestic cases. That is only in the probate guardianship cases. Okay, thanks everyone.
Thank you. I think we're still changing the agenda to having lunch after.
Well, I think, but I'm not sure if lunch is actually here yet.
Okay.
But yeah.
Awesome. So I'll continue. Our first CLE word is spring, so make sure you write that down. So you won't need that for your evaluation towards the end, and but you can get CLE credit. All right, so I'm just gonna overview of working with clients. A lot of it.
If anybody needs to go to the bathroom,
Yeah.
why don't we do maybe like a 5-minute bathroom break?
That's great.
Stretch your legs, and then we'll come back for the last literally 15 minutes. Okay, so why don't we say we come back at 1:50? Oh, sorry,
No,
I'm looking at the wrong. 11:40.
11:40. Thank you.
Is it going?
Oh,
I do want to.
Last 15 minutes, please.
Yeah.
Yeah. Sorry now. Thank you.
Lunch is here, so finish the last couple of minutes.
Yeah.
You were number one.
Thank you. So yes, for the next part, I'll be working with clients. It's a lot of repetitive stuff. I'll be skipping around. Just giving you the important details with working with clients. So again, the client here is a parent or proposed guardian. And a lot of like guardians are aunts or even siblings, just making sure that they're older than the child. We do tend to meet with the clients in person to help to build a rapport. But if remotely works best for the family, if they live too far, please get that contact information and just prep them. The judge might want to talk to the older child, so it'll be best to like meet today and talk to the older child as well. And then from the start, apart from their phone number, please get their WhatsApp, Facebook Messenger, Google Voice, and conference calls. So just double check if they have a computer and Wi-Fi working, because many of these families like might not be living at home, might be in a shelter or somewhere else. So making sure you have that. And Facebook and WhatsApp Messenger will give you access to like pictures, text messages, and even video chat with your client. If you have more questions about that, I'll talk to you later. But those should be easy access for them.
I want to point out too that conference calls is on here specifically because those can be tricky. So to the extent that you need to like virtually communicate with your clients, things like WhatsApp are your friends, text is your friend, conference call where they have to punch in a bunch of codes at different times, that's not your friend. That is gonna be more difficult. So like the easier and the more like youth friendly.
Yeah.
If you have a TikTok, I'm just kidding. But like WhatsApp and Facebook Messenger, we really do use a lot with our clients, WhatsApp in particular, because you can get on a Wi-Fi to do it. You don't need credit on your phone, which means if you haven't paid your phone bill because you can't afford your phone bill, you still have the ability to get in touch. So that's why we specifically recommend those.
Yeah, and I don't know whether I'm allowed to say this or not, but, and NIJC, correct me if I'm not. But in a lot of these cases where the kid is like 17, 18, 19, 20, like I end up doing a lot of the communication with the minor directly because a lot of the adults may not be tech savvy, they may not have email. So if that's permissible, that is something that comes up a lot.
Yeah, and a lot of our parents do work, so sending a text before calling is like key here. Or even the child might be in college or in school and they can't text during that time. Just sending a follow-up text later and then calling would be best.
But this might all be through interpreters?
Oh, yes.
So how does that, will you get to that? Right?
Yes.
Okay, great.
I'll get to that part in a minute. Please confirm their best phone numbers, email addresses, alternative safe numbers. So that being a friend, a neighbor, do not disclose their case. Just be like, hey, I'm trying to contact this person. Just let them know to call me back. Again, establish the best time and phone numbers and see if they have a voicemail set up, because sometimes like teenagers don't have a voicemail. We don't listen to voicemails. So maybe setting that up together would be best. And if you're sending docs, so for example, engagement letters, which are being sent out later, I'm guessing, please make sure there's a safe address and follow up that they got the letter and that they know how to send it back to you. So that being USPS, FedEx, UPS envelopes. So always confirm that they are in a confidential place and just pay attention to their tone and their background noises. Sometimes if they're not in a space to speak freely, you can call them later or have them come into the office, right? Use verbal cues to indicate that you're listening and being sympathetic. So saying thank you or I'm sorry that happened to you. That really helps with building rapport with the client.
We call that our being a human rules for years, like we're maybe some of us not used to that because we're talking about like mergers and acquisitions with very, very rich people and it doesn't matter how they feel about it. Just remember to like be a human when they're talking to you, respond, say, I'm
Mhm.
sorry that happened, say, thank you for sharing this, etc.
Yeah. And then always use an interpreter. So meet with the client and in their best language. I know some languages are rare to find, but with the resources, you should be able to find the best interpreter. And as I said, the pro bono attorney is responsible for providing the interpreter. So a family member and NIJC, as a reminder, cannot serve as an interpreter for your conversations. If you do have more questions about working with interpreters, we do have a webinar, and I'm happy to share some suggestions. I do have a list of like providers if you don't know where to start, so I can share that with you. Just remember that meetings do take twice as long when working with an interpreter. And when you're using an interpreter, try to talk to the client instead of like saying, can you ask him or her? Just have a normal conversation and do not use like legal jargon. Do not use full sentences. Keep it short so the conversation goes with the flow. And then for better understanding, just ask the client to repeat back. If they don't understand, then you should repeat it back, right? Again, you don't know what the client is going through. So with the pandemic, there might be like poverty and food resources that they don't have, or they're on certain immigration status, right? So they might be stressing over that. So if you're going to have them in the office, for example, provide food, provide a safe place for them to talk to you. And yeah, I have a pyramid of hierarchy here where it reminds you of like where to start off, right? To build that rapport with the client and building up from there. Everybody needs like love and like security to get to that point of trust. So it's just a reminder. And then I handle the pro bono case. So if you need a pro bono case in the future for SIJS, just email me or Ellen, and we're happy to provide you another case. We currently have like 9 cases, but it's always growing and they move pretty fast. So yeah.
Can I ask one question about interpreters? How does it work practically? So if you're trying to coordinate a call, set up a call, but you don't speak or write in the client's native or preferred language, how does that work practically? And I don't know, Marianne, if you have suggestions for the firm how to do this?
We have full access to language line, and so for setting up calls, things like that, we can definitely we can get the language line on the line. In terms of like if you're trying to send a brief email or a text, we actually have translation tools it's built into our engagement agreements that we can use translation tools to translate like messages and things like that. And we're not worried about like minor like little things. The translation tools are quite good. So we can use those for sending emails and text messages and things like that.
Yeah. So don't try to muddle through.
And then we also, for actual meetings, we can help connect with actual interpreters.
Yeah.
Great.
Yeah, thank you so much. And for today's meeting, clients are here actually, and they want to meet you and get to build rapport with you. And I know there's no engagement letters today, or if you have like other signature pages that you have to sign for the predicate order, we'll check those later. So you don't have to draft anything today, just get to know them. Do not go into depth interviews, and then explain the process, and we'll be going around for questions. If you have any, and hopefully you've gotten time to review your packets, which tells you the story and contains their birth certificates, and most of them, the death certificates are there too. Yeah. Oh, very important. The clients do have a chart with them, which Dominique provided to them. Thank you so much for that. Where multiple clients have multiple cases with NIJC, so it gets a little bit confusing with attorneys. So if you want to go ahead and write your name and best contact information or the best point of contact for your firm, that would be great.
I also have them printed for kids' team too, if you guys want to use those.
Always inform us immediately if an attorney is joining the legal team. or if another attorney from the firm is taking over the case. That way we can like communicate efficiently and provide that technical support to you. Second, legal, CLE word is break, spring break. We're ready for that break.
I would be that, like, this is what I wish I still had. Long time ago.
Yes, and you should, this is my contact information again, and then Rebecca's contact, but I'll CC everybody in the emails. And this is a QR code for the evaluation, so you can scan that now and put in those keywords and you'll get a CLE certificate, later.
Love to see all these cameras up.
Yeah.
It's way better than trying to trap you at the door with evaluations to fill out before you leave.
Right, and then we'll take a break for lunch. You'll eat lunch with your clients if you want to, yeah, or get something before.
So just to be clear, then the objective of today is to develop a communication plan, meet your clients, but not necessarily start on forms. Is that what I understand?
Correct.
If you do have, I think I put a bullet in there about signature pages. If you have had a chance to already print those out, what we frequently will do is when we have a client here, we can have them sign a blank signature page and then we can use it later. If you haven't done that already, that's fine. Just make sure that you're then talking to your client about how and when and where you're gonna get those signatures.
The reason being that our clients, are low income, and so they can't just take time off from work or get kids out of school or just kind of drop of the dime if something's missing. And so we like to sometimes preemptively get some signature pages out there, or try to like make meetings very concise and to the point and get everything done ahead of time. But the clients know that they should expect to be meeting at least maybe one more time in person. And then on top of that, another at least one hearing date. So they have been made aware of that, but just to be kind of cognizant of that, yeah. And some clients will sometimes ask for like, for example, some of the kids for school, they need a school excuse letter. We have a template for that, so we would happy to share that, just to kind of confirm that the child was at a meeting and so that they are not marked as absent. So one of those things again that like, if you sometimes we don't think of those small things, but those are some things that can add up, especially with clients who have, if they miss time for school or work, that could affect their ability to communicate with you or to work on this case.
So Dominique and I are your assigned tech support attorneys along with Rebecca from CVLS. We will be walking around. If you have questions as you meet with your clients or after you've reviewed your documents, grab us. This is what the Q&A part of this clinic is for.
Yes. So I think now that's the end of our training. I believe Marianne said that the food is here, and then we'll move into rooms. But Marianne, if there's anything else you'd like to add or.
No, just thank you so much for this incredible comprehensive training. And I'll be letting you know like where your client, I'll be introducing folks to your clients. So your both students. Thank
I
you.
guess one question for those that are online, are they going to be joining client meetings as well?
Not today,
Okay.
but they're going to be, so we're talking about the next one. Yeah.
Perfect. Okay.
Yeah.
Perfect.
Thank
I
you.
did send like an assignment page where your teams are, but if you have questions, I'll be right here, tell you like who's yours. Awesome, Marianne has them.
Thank you so much.
Right.
Thanks.
Thank you.
Thank you.
I'll give you mine as well.
Okay.
All right.